This is Bloomberg Law with June Grasso from Bloomberg Radio.
Senator Bob Menendez says he'll appeal his conviction on 16 counts of bribery, extortion, fraud, obstruction of justice, and acting as a foreign agent of Egypt. The 2-month corruption trial focused on 13 gold bars, nearly $500,000 in cash, and a Mercedes-Benz seized at his home. What didn't get as much attention was the unusual and aggressive move by federal prosecutors to charge Menendez with obstruction based on a presentation made by his former lawyer to prosecutors before his indictment. Joining me is former federal prosecutor Ariel Neuman, a partner at Bird Marella. How common is it for defense attorneys to be meeting with prosecutors to try to talk them out of bringing charges?
So in this case, we're talking about pre-indictment, meaning before the defendant is charged. And these meetings are very, very common, especially in the white-collar context where we're talking about fraud crimes of some sort. The meetings take essentially two forms. One is what we call a pre-indictment pitch meeting, where we are going in and making the case to the prosecutors about why they shouldn't pursue a case against our client. And it may be legal arguments, it may be factual arguments, but we are trying to convince them that they don't have a case, or for whatever reason, they shouldn't pursue a case that they think they have. The other kind of pre-indictment meeting is what we call an attorney proffer. This is where essentially you've made the decision, or your client has made the decision, that they're going to cooperate with the government's investigation, potentially provide testimony against other people. And so before you have them sit down with the government, you want to preview what they're going to say, and there's a discussion if the government thinks there's any problems with it, if they think that certain things may not be truthful. You can have that discussion before you sit your client down and suddenly everybody is yelling that they're lying and not being forthcoming.
Are these meetings usually considered confidential? Can the prosecutors use the information that's given to them at trial?
Let's focus on the pre-indictment pitch meetings, the efforts to convince the prosecutors that they shouldn't pursue the case, because that's what the Menendez case was. Usually there is an agreement, or there's a request for an agreement by the defense lawyer that these are protected as settlement conversations. There's a federal rule 408, rule of evidence, that says settlement communications can't be admitted for almost, and that's an important almost any purpose at trial. And so generally, the expectation is that these are going to be largely confidential. And then the caveat to that is sometimes there is an agent, let's say an FBI agent, who is taking notes during the meeting. If that's happening, you tend to know that it may not be as confidential as you hope. Also, I mean, I've had it where, it was a surprise to me, but, now I've become cognizant of the risk. They write a report and then they produce it in discovery. If the government goes ahead and charges your client anyway, now it's a multi-defendant case, right? There's other people who are charged in the case along with your client. And suddenly they are seeing a report about what you said during that meeting where you were trying to convince the government not to charge your client. In the case I'm thinking of, it was everybody else's fault, not our guy's fault. It certainly wasn't helpful to relationships among people as we went forward with the case.
I mean, was that in a case where you thought what you were saying was not to be used?
Yes, we thought it was a confidential settlement meeting. They never tried to introduce it at trial, but there isn't really anything prohibiting them from doing what they did unless you have an agreement explicitly that they won't. And I have found more and more as I've asked for those agreements that prosecutors, and especially prosecutors from what we call main justice, DOJ in D.C., as opposed to the local U.S. Attorney's Office, are less and less willing to have any sort of agreement about what they're going to do with the information you provide. But what happened, in the Menendez case, honestly, I've never heard of that before, and everybody I've talked to has never heard of it before, where the government or the prosecutors in that case charged the defendant with obstruction because they claim the lawyers provided false factual information during those meetings, which they say the lawyers got from the defendant. We are always talking about facts during these meetings. We're making legal arguments, but we're also making factual arguments. And I've never heard of, and like I say, nobody else I know of has ever heard of, the government charging obstruction based on what you say during those meetings.
So in this case, Abby Lowell, a very well-known, highly respected attorney, white-collar attorney, was the lawyer for Senator Menendez. And he actually made a PowerPoint presentation entitled Senator Robert Menendez, Presentation to U.S. Attorney's Office, Southern District of New York, September 11th, 2023. Is that unusual to have a PowerPoint presentation?
Not at all. Very common. It helps outline the discussion, helps frame what you're going to be talking about, and hammer home the points that you want the government to focus on. So very, very common to have a presentation, and I think important in any of these presentations that's all it is, though, is maybe an outline or maybe just a couple bullet points on a screen, maybe a couple pictures or citations to cases. None of us are putting the entire context of what we're going to say up on the screen. In fact, my practice is edit it down to the fewest words possible so that the PowerPoint isn't distracting and everybody's not reading it. And so what you generally have, and I can't say I have any insight into what Mr. Lowell did particularly beyond what's been publicly reported, but what I would assume was that he and his team had an outline where that had the real content, the real details of what they were going to say. And then they had a PowerPoint, like I say, to help frame the discussion and maybe hammer home key points along the way.
The judge allowed the government to introduce at trial pages from that PowerPoint presentation. I mean, what about attorney-client privilege? What about attorney work product? Where were those concepts in this?
So attorney-client privilege, once you share with the government, let's say, what your client said, then it's free game, right? You've sort of waived, at least as to those statements, arguably the privilege. Depends how you say it, right? My client told me X. Oh, that's pretty much a waiver. But the attorney work product is a different question. And again, I don't want to criticize people without knowing what was going on in the back rooms and the back decisions. But generally, my view is that we shouldn't be giving the government our work product, defense lawyers. We shouldn't be giving them our PowerPoints because they can, as it appears they did here, take it out of context, right? I think they put in 4 pages from what was obviously a longer PowerPoint into evidence. And the defense, as I understand it, was really stymied in their effort to get in any of the context around that. And it's that context where the caveats are given, where the lawyers are making sure that it's understood that, this may not be exactly what the client said. Maybe this is what our investigation has shown or something else. But without that context, it becomes very difficult to get the full picture of what was actually said during that meeting.
At the Menendez trial, did they try to get Abby Lowell on the stand?
So there was discussion. I know that I think actually at some point the defense wanted to call him if the government was going to be allowed to put in certain other documents. And as I understand, none of that happened. But as I understand it, what happened at the trial was the government put on a paralegal who had been present to talk about and essentially authenticate these PowerPoints. And the defense really struggled because of objections to even get out the idea that more than what was on the page was said during the meeting. Eventually that did come out, but both sides, as each was examining this witness, everybody was objecting like crazy. And my sense, at least, is I wasn't in the courtroom, but my sense from what I've read is that the PowerPoint went in and probably not a lot more about what happened during that meeting was presented to the jury.
In light of this, you have written for Bloomberg Law some advice for defense lawyers in these situations. First, whether to even have the meeting. I mean, how often are defense lawyers successful in getting prosecutors not to charge their client? Is it worth even having one of these meetings?
I've done it, and I know people who have had success. It depends where the government is in the process and how good your facts and your arguments are. It is certainly, in many cases, worth making the presentations. First of all, often in advance of that, you have discussions with the government where you can learn more about their case. And it gives you a chance to find out sometimes where the holes are in your arguments as well, right? If I come in and I make some argument, the government says, oh, that's all well and good, but what about XYZ? And for whatever reason, I didn't know about XYZ. Well, now we're more informed going into the next decisions about what we're going to do. The big downside to making these presentations, traditionally, the big downside is that you're showing your cards to some extent. You're going in and you're making your pitch to the government, you're arguing your facts, you're arguing your evidence, and The sort of conventional wisdom is that allows the government to shore up their case as well, right? They find out where their potential holes are and where the weaknesses in their case are. And so it's certainly a balancing decision in every situation of whether you do this meeting. But in many cases, it's worthwhile. And in many cases, the client is really pushing because, right, they're facing the prospect of federal felony charges, and this may be the best shot they have to avoid them, or at least they think that. And that's one of the things I talk about is how to resist that pressure or whether to resist that pressure. It's not always so easy when the guy paying the bills is telling you, do something to stop this, please.
Are there any magic words that you should say at the beginning or you should have put in writing so that you avoid a Menendez situation?
Well, there are no magic words. I think that's probably the starting place. And so you just have to be careful and clear as you approach this. And one of the main things is I do think it's worth getting an agreement that these are settlement communications, and that at least gives some protection to how anything that comes out of the meeting might be used in the future. And a big one that I think we see here is where at all possible, not to source the information that's in your presentation to your client, meaning not to say, my client told me X or my client says Y about this situation. And I'm not sure that's what happened here. But once you say that, you are then really putting the client on the line and their credibility on the line. And so what you want to do is talk about the fact you've done an extensive investigation, you've talked to the people you can talk to and looked at the documents that you have access to. And based on that, this is your understanding of the fact. That way, you're not sourcing it back to somebody who, in this case, the government said, well, Menendez and his wife Nadine told their lawyers to go in and make these statements to the prosecutors in order to obstruct justice. Well, it may be that if you can caveat it correctly, it's not clear where the statements came from or that the client told you to come in and say it. Obviously, you're not going to say the client reviewed and approved my presentation before I came in. You're not going to get into those communications as well because for the same reason, you don't want to put the client on the line.
Do you take your client's word as fact or do you do investigations?
You need to test what the clients tell you because people's memories are different. People, whether willfully or unintentionally, may not remember things perfectly. There's other witnesses out there who may or may not be saying things that are consistent with what your client is telling you. There may be documents that your client isn't aware of or that your client forgot about. And so it really is important to educate yourself before you go in, whether if there's other people involved who may also be having conversations with the government, talking to their lawyers under a common interest or joint defense arrangement to find out what did they say, how was it received, what did the government say in response. Talking to them about what their clients would say. If their client was presented with this version of events, what are they going to say about it? Because the government's eventually going to learn a lot of those facts. Yeah.
We always hear about FBI notes and things and FBI notes being there that shouldn't be there and missing things. So what do you do to ensure the veracity of the FBI notes?
So we always bring someone with us and essentially instruct them to take down almost every word that is said. And this is ideally a paralegal, a non-lawyer, somebody who can testify. My experience when I was a federal prosecutor and then now on the defense side and on the receiving end of these reports is agents from any agency, whether it's FBI or Secret Service or whoever else it may be, they take down what they think is important. And your caveats are not going to be what they think are important. Your sort of hedging around what you say and putting context around what you say is not going to be the kind of thing that goes into the notes. It's the same as when they interview someone. Often I find that the no's or the I don't know answers don't make it into the report, whereas only the affirmative statements do. And of course, the no and the I don't know could be very critical, but for some reason, often that's excluded once I see the report of an interview where I was present. So I always have somebody with me, and like I say, somebody who could, if necessary, testify as to what our recollection and our notes show from the meeting.
So in talking to other defense lawyers, do you think that they're more aware now or more afraid of what might happen in these meetings?
I think this prosecution, for people who are aware of it, sent a bit of a shockwave through the defense bar. like you said, I wrote this article, and I haven't had a reaction like I had to this article from the defense bar. People pointing out to me that they are changing their practices, people responding that they've never heard of this, and they're going to have to think about it going forward. We're going to have to see whether this was an outlier, very aggressive prosecution, or whether this is something that is going to be a new tool in the government's tool belt, and we're all going to have to be cognizant of it. So I do think it's going to change, or at least make us more cautious as we go into these meetings. And I'm certainly going to. I've always been aware of being careful of how I frame things and how I say them as I'm going through, but certainly something I'm going to emphasize with my teams going forward as well.
Just a few questions about the appeal. And the Supreme Court has been narrowing the definition of corruption for more than a decade, and we've seen a lot of political figures get their cases reversed. I mean, is that a good argument, do you think, for Menendez? It's one he'll bring up?
First of all, I'm sure it's something he'll bring up. I've had bribery cases, public corruption cases, and this is sort of where the rub is right now as the Supreme Court is going through and, as you say, narrowing the definition of what we call an official act. And so I would be shocked if they don't focus on that. They were focused on it in the pretrial motion practice and then again during the trial. And as I look at it sort of from the outside, it seems to me that they've got some good arguments and they've got some that may be more of a challenge. It's really about whether Menendez was using his official position on any decision or action, on any question, matter, cause, proceeding, or controversy, which may be pending before him in his official capacity. So, for instance, he, as was alleged, interfered with a state prosecution by calling up a state prosecutor and saying, hey, maybe take another look at this. Well, that's not really something that's pending before him, and maybe a harder argument that that's an official act. He doesn't really have an official role there. He's sort of using his influence and position. Whereas maybe, as he's alleged to have interfered with the nomination of the U.S. attorney from New Jersey by essentially corruptly making a recommendation to the president of who to nominate. Well, that may be closer to the line because that is the traditional function of the senator from a particular state. They make recommendations, especially when they're in the same party. Those recommendations are often followed, and that is potentially something that was pending before him in his official capacity. So it seems to me that, as I say, from the outside, they may have some luck, but I'd be surprised if they can fully get everything reversed. And that's just one part of the case. Obviously, there's other pieces that don't rely on that official act element. Those are going to be harder for them to succeed on, from what I can see.
Do you think that his being, an agent of Egypt, that's one that's easier for them to attack?
I think what you have to look at is the full picture, right? Because the argument, as I understand it, and I would frame it, is essentially that legislatures, and especially a senior senator like him, who's doing the foreign affairs work that he's doing, are going to have contact with foreign officials and are going to take positions that may be to the benefit of a particular country, in this case, Egypt or Qatar. And so that's just sort of part and parcel of what they do. And they even raised the idea of the speech and debate clause, right? This is part of his official functions as a member of Congress. The challenge in a case like this is, well, what about the rest of the picture, right? And here it's the cash and the gold bars and the deleted messages and so on and so forth that I think, the jury obviously felt that takes it out of the realm of what you're doing in your official capacity and puts it more into the realm of something that is corrupt. And so that's what's going to be the bigger challenge, I think, on appeal is how do you question the jury's verdict in light of the full scope of the evidence? And that's always what makes these cases difficult.
A lot to think about. Thanks so much, Ariel. That's Ariel Neuman of Bird Marella. The Supreme Court's Republican supermajority acted with impunity this past term, slashing the power of regulators, making it harder to challenge racial gerrymandering, allowing homeless people to be punished for sleeping in public places. And perhaps the most controversial, a decision giving Donald Trump immunity from criminal charges for some actions taken while he was president. It was the third term to finish with landmark rulings that included overturning precedents. In the two previous terms, the court eliminated the constitutional right to an abortion, declared a right to carry handguns in public, expanded religious freedoms, and outlawed race-conscious college admissions. Polling consistently shows that Americans disapprove of the Supreme Court, with new polling from Fox News finding that 6 out of 10 Americans view the Supreme Court's job performance with disapproval. For years, Democratic lawmakers have held hearings, proposed legislation, and even introduced articles of impeachment that would make the Supreme Court accountable, to no avail. Joining me is constitutional law expert Olatunde Johnson, a professor at Columbia Law School. Start by giving me your take on just how far to the right the Roberts Court has gone and where it's headed.
I think we would say that this is a fairly far-right court. And when you look at some of the decisions on issues like abortions, guns, race, voting, affirmative action, administrative power, presidential power, so the court has been really strengthening the power of the executive branch. So you see this in the presidential immunity decision, for instance, but then weakening the power of agencies, which generally try to advance policies that are regulatory, like environmental policies. So when you look at those kinds of trends overall, I'd say this is a far-right court. Those terms are very imprecise, of course, but it's implementing a lot of the agenda that conservatives have wanted the court to implement on some very key issues. Another feature of the court that's particularly striking is its willingness to overturn longstanding precedent. So just this past term, we see the Supreme Court overturning a precedent in a case that lawyers just call Chevron as a shorthand. A lot of non-lawyers don't know about it, but it had a principle of deference to agencies, that courts should defer to agencies' reasonable construction of statutes. And this was important because Congress often writes statutes, like take an environmental law very broadly. It doesn't often update it. And so this would give power to agencies to interpret the statute, and often agencies did this in a way that encouraged more regulation of areas like environmental law. So the Supreme Court overturned that longstanding precedent, which really weakens the power of agencies. I think everybody knows at this point about Dobbs, which overturned Roe versus Wade, and then in the affirmative action area, you see the Supreme Court not squarely overturning, but really so far weakening prior precedent that allowed universities to consider race as one among many factors in composing a class of qualified students. And so these are big changes. You see, it's a court that some people have called imperial because it is willing to overturn precedent.
We've heard for years and years John Roberts say that the Supreme Court justices are not politicians. During this term, we saw in an appearance with Justice Sonia Sotomayor and Amy Coney Barrett, again, we're not politicians in robes. But does this term show that justices are politicians who generally vote along the lines of the president's party they were appointed by?
Yeah, I think that's generally true, or it's turned out to be true with this court. I don't think it's always true in the course of American history, and that may be what they're referring to. I'm a lawyer who teaches constitutional law and other topics and also has argued before the court. So even I hesitate to have the idea that judges are just and justices are just politicians in the sense of trying to enact particular partisan goals, like help the Republican Party. That's a really hard idea for most law-trained people to get their minds around because it's a very cynical view of the court if it's true. But I think there has been a real questioning lately if the judges abandon some of their ideological or legal commitments in order to have partisan outcomes that they agree with. I think the complicating factor is that we know the judges are appointed in a more either conservative or liberal bent, and that they have different views of these key questions even before they go in. So in other words, it's not just that they're trying to achieve partisan outcomes. This is their view that there's no abortion right under the Constitution. It's no surprise. So Trump, it was a goal to appoint a certain number of justices to overturn Roe versus Wade. So is that partisan or political, or is it just those are their ideological commitments and they followed through on them? I don't know if we can completely answer that debate, but I think you can fairly say the Republican Party and conservatives are more happy with the court than are liberals right now.
President Biden has reportedly been planning to unveil proposals that could dramatically reshape the Supreme Court. And one of those proposals is something that we've heard over and over again through the years, term limits. The past 5 justices to leave the court each served nearly 3 decades or longer. So what's the opposition to term limits?
Well, it's really interesting, this question about what is the opposition to term limits, because historically, Republicans and Democrats, liberals and conservatives agreed broadly, at least in an abstract sense, on the notion that there should be term limits for the Supreme Court. It's an idea that if you were operating from first principles, a lot of constitutional scholars would agree that there should be term limits for the Supreme Court. The United States Supreme Court is really an outlier in not having either term limits. A lot of systems, they could be 7 years, 12 years, 18 years, in neither having term limits or a retirement age. And the effect of that is to have justices that are on the court for a really long time. Yes, our Constitution has a provision that is easily interpreted to require term limits, although that is something debatable. But the key thing is that at the time of the founding, people lived much shorter lives. And so partly is that, there is the problem of having people who are on the court for a long time. But I think more than that, it's the lack of predictability. There's no sort of routine in every presidency getting an appointment. It just is something that can fall through chance. And then conversely, it can also be gamed. People can stay on the court and only retire when they are aligned politically with the president, or as we saw in the last few months of the Obama administration, they can hold up nominees and not allow a president to move forward on their nominee and hold it open, anticipating that a Republican or in part someone from another party can get in office. And so that all allows a lot of gaming of the system that makes the court not necessarily align with the politics of the nation or even the politics of a particular president.
And what would be needed for the justices to be subject to term limits? Would legislation be enough, or is a constitutional amendment required?
So this is another good question. Okay, so there is a view, and this is really outlined in the commission report. President Biden put together this commission, and in it outlined different kinds of strategies. So one way would be to do it by statute, and there are a number of constitutional law scholars that say that you can enact term limits by statutes. The current prevailing proposal that has gotten the most amount of circulation is 18 years. And the question of whether or not it can be done by majority or supermajority is less clear. So there are a lot of people who think it could be filibustered, and so that you effectively need a supermajority, at least in the Senate, to do it. There are others who believe if you can get it done politically, you can do it as a constitutional matter by just a majority vote. So there's that group and analysis that says you can do this by statute, but there are constitutional law scholars that believe that you have to amend the Constitution and that it conflicts with the current provision of Article 3 that says that justices can serve and only be removed essentially for violations of good behavior. So the tricky thing is that very issue, whether or not you can do it by statute or by constitutional amendment, could in theory be challenged and be before the same Supreme Court that you are trying to restrain right now through term limits. Certainly the president has no authority to create term limits. It has to be done by Congress or by constitutional amendment.
And what's your opinion on what would be needed?
I think it can be done by statute, but I don't purport to be an expert on that. There's some people who are more expert. I was persuaded by the analysis in the commission report that said that you could do this by statute.
Okay. Another proposal, and this really seems like a no-brainer to me, an enforceable ethics code for Supreme Court justices. In light of all the alleged ethical violations by Clarence Thomas, some by Alito.
Yeah, so I think the last year has really demonstrated a need for a firmer ethics code. So there is the issue of things that create an appearance of impropriety or actual impropriety. So giving gifts, monetary gifts to justices. I mean, this has happened with regard to Thomas, and some of that was not disclosed. Then there are also issues of appearance of impropriety because of behavior. This could be speeches. This could be you or perhaps your wife flying an upside-down flag before you have to rule on a presidential immunity decision. So these things absolutely have created for far too large a segment of the population. This feeling that you alluded to in some of your questions, which is that people are questioning the legitimacy of the Supreme Court. They see it as a partisan institution, and I think even more dangerously might see it as corrupt. You get to things like gifts. And so the arguments are for strengthening the ethics code. I mean, the Supreme Court had a really very weak ethics code and then somewhat strengthened it, but still it didn't in key ways. And so the proposals that are currently underway would have a congressional statute that would strengthen the recusal rules, and that means a justice has to step away from a decision if there is impropriety or an appearance of impropriety or a conflict of interest, and has to explain why they're doing so or why they're not doing so. So just stronger recusal rules. The other parts of the proposals are for stronger financial disclosure. Right now, the financial disclosure rules are considered by some quite weak, and the point is to make them what the House or the Senate has to do. They have really detailed and clear financial disclosure rules and gifts and things like that. So that's the pro, is that would make all of us trust the court more if we understood how it was ruling on these questions of conflict and appearance of impropriety, and also that these rules would be enforceable, right? Because right now it's the Supreme Court itself that decides, I just don't want to recuse myself in a particular case, and it doesn't explain it. And so you would think this would be low-lying fruit. The questions that I think are coming up about them, one is political. I think that in the abstract, conservatives and Republicans would agree to these rules, but because they're right now caught up in sort of larger criticism by progressives or Democrats about the court, there are many Republicans who are not willing to sign on, where maybe if the court were differently arranged politically, they would have been willing to sign on. So I think that's one thing. There are some constitutional questions that have been raised by this, although I think they're even weaker than the term limits questions, which is the notion that Congress cannot create any of these rules. In fact, Justice Alito has said this, that Congress doesn't have the power to regulate the court in this area, and that this would be a violation of separation of powers. That argument is out there. I think it's a pretty weak argument. Congress already does have some regulation of the Supreme Court, and what it would envision for our system, I think, is very dangerous. A court that the most democratically accountable branch, which is Congress, could not regulate at all, I think is a very dangerous idea of the power of the court. So I've thought that this politically was the one that was more likely to move forward, regardless of Biden's endorsement. But even it has not moved forward so far in the last 2 or 3 years of being proposed.
Coming up next, other proposals to reform the Supreme Court. You're listening to Bloomberg. Every recent poll shows that most Americans are not happy with the Supreme Court. But what can be done? I've been discussing some of the proposals with Professor Olatunde Johnson of Columbia Law School. So, Democratic lawmakers have held hearings and proposed legislation to hold the Supreme Court accountable, but I can imagine that the average person who hears about Supreme Court reform all the time and sees nothing being done, it seems like nothing will ever happen to make the justices more accountable and to make the Supreme Court more transparent.
Yeah, I think a challenge in this area is getting the average person to prioritize it as an issue enough to put pressure on their congressional members, because it's something that Congress has to elevate. And I don't want to say that something's never going to happen. I'm not an expert on the politics of this, but what I can see when I look at the overall ecosystem is that we're talking about the court more now than we have in the whole time that I've been a lawyer, certainly. So I'd say in the last 30 years, I'm seeing a lot more discussion of these issues by people who are not experts. And there's a lot more interest in what is the court doing in terms of its rulings. People have been talking about things like the court's methodology of originalism. I think a lot of people are conversant in questions around term limits. So that could translate into ordinary citizens making these questions of ethical reform and court reform higher on their own political agenda. The balance is just that there is a partisan balance to the urgency of it. Democrats care more about court reform right now because they're more discontent with the court than Republicans, and that can catch this issue in the same kind of patterns of polarization that affect other areas of American politics.
So I haven't heard for a while, suggestions of expanding the court or so-called packing the court. Has that just gone out of favor even to try that?
My sense of that issue is that there's not enough political support for expansion, and mainly that there's not support among the president. So the issue of expanding the court, this is something that Congress could do. I mean, it's already happened in American history. It does not require a constitutional amendment at all. I don't think there is a real view that it requires constitutional amendment. But between Congress not having enough support because it's locked up in a partisan gridlock, and the President Biden himself not supporting it, I'm not sure if it's going to go forward.
President Biden has always been reluctant to make any changes to the Supreme Court. And the theory is that these proposals were made in order to help him with progressives. Now that he's dropping out of the race, it seems likely that these proposals will also go by the wayside again.
Yes, it certainly could fall by the wayside again. I don't know firsthand about the politics. I'm here comfortably in New York City, and while I used to work in the Senate, that was a long time ago. But my sense of the politics is that, he did this in part to shore up some support among progressives. I think the issues of term limits and ethical reforms, though, are something that could have broad-based support. It doesn't have to just be a progressive issue, as I mentioned before. But it might not, if nobody feels that they need to prioritize this issue for political gain, meaning whoever is the next Democratic nominee, it might be a while before anything goes forward. There's also the issue of Congress itself. I would be skeptical if anything went forward before November. I think this is just a time for those who really are concerned about this issue to continue to educate American people about it, to have discussions at every level of the citizenry and of government actors and legislators about the possibility. So it's a time to continue to have hearings, but also just discussions so that people understand this. And I like that move. I don't think that the Supreme Court should just be an unaccountable institution that nobody understands and thinks just drops decisions from on high that we all have to agree to. I think ultimately an institution depends on all of us understanding it, believing it operates in the way that it should in a modern democracy. And so I'm happy that even if these issues don't go forward immediately, that people are talking about them and that they're on the table.
People are also talking about Amy Coney Barrett and how she's the Supreme Court justice to watch, how she breaks with the conservative majority on occasion. But whenever there's a controversial issue, her vote is with the 5 other conservatives. So what does it matter if she has a different approach to history and tradition and originalism if her vote is always with the conservatives on the key issues?
Maybe it signals for her that she is open to thinking about these issues in different ways, and maybe that is something that we see in the years to come. But on the cases that people have been watching the most, she's fairly aligned with the conservative majority. I don't see that much space there. I think it's one thing, if people write concurrences, you see this a lot, but don't really create any space in the actual vote, then that tends to be mostly of interest to law professors. But sometimes those things, they change down the line. That's one of the things that some people see as the benefit of having justices who stay on the court for a little while, is sometimes their views do change.
And people often talk about justices who've changed when they're on the court, becoming more liberal in several instances. But weren't those justices chosen before the very serious vetting that Supreme Court justices go through now, where it seems pretty clear what their positions are and where you have the Federalist Society making these lists of candidates that they're sure of.
Yeah, I do think that has played a role, is the idea that you want these judges who are more ideologically committed, and they're sort of different people in some ways. So, I mean, I clerked for Justice Stevens, and he was appointed by a Republican, and he was not vetted in that way. I mean, I think he was broadly considered to be a Republican, but by the time he left the judiciary and retired, I think a lot of people associated him with the more liberal wing.
Right.
But he did change his views on a lot of issues, and it's because of his temperament. He was open-minded, and he was willing to listen to different arguments. He was independent-minded in a range of things. Like his views didn't always go lockstep in a liberal or conservative direction, even at the beginning or at the end, right? Uh-huh. And so I think that kind of temperament, it's unclear to me whether that's valued as much. I think it's really important in a judge, and that's different from being an advocate. As an advocate, you can be like, this is what I want as an outcome all the time. As a judge, you have to make arguments that stand up to reasonable inquiry and debate, and you don't have to be absolutely consistent over time. You can change your views, but you have to be able to explain your decisions and your outcomes, and I don't know if that's what we want in justices anymore.
Maybe some of us want that. Thanks so much for being on the show. That's Professor Olatunde Johnson of Columbia Law School. In other news today, the first congressional hearing into the attempted assassination of former President Trump. The House Oversight Committee heard from Secret Service Director Kim Cheadle, who during her opening statement took full responsibility for any security lapses.
The assassination attempt of former President Donald Trump on July 13th is the most significant operational failure of the Secret Service in decades, and I am keeping him and his family in my thoughts.
Cheadle vowed that an investigation will uncover the missteps, but lawmakers on both sides of the aisle are calling for her to resign. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.